Good morning. I'm very pleased to be here today in Brussels today to speak to you about current trends affecting the attractiveness of the legal professions in Europe. Regarding this topic, there is good news and bad news. Last night when I arrived at my hotel, I switched on my TV and there was a talk show on discussing the dangers for the economy resulting from a lack of skilled workers. And getting depressed hearing that, I switched off and went on Twitter, and one of the first tweets that came up was on a report that was published the other day in England that the English school system failed to attract teachers for 17 of the 20 subjects because there were not enough university graduates who wanted to become teachers. So the good news is you're not alone as the legal profession. It's a common problem in all professions, in all walks of life. But the bad news is everybody is thinking about how to become more attractive, how to attract more talent. So what do I plan to do in my presentation? I must start by pouring a little water into the wine and dampening your expectations. In my presentation, I will not be able to present findings for the entire European Union, the European Economic Area, or even Europe per se. The future of the legal professions, their apparently dwindling attractiveness, cannot be properly addressed by pretending to be able to present insights for dozens of countries in an area with more than 400 million citizens, in an area with still quite different internal structures of the legal professions and the nation states, with different demographic characteristics of the population and different histories of the legal institutions. All these differences determine the future developments in each of the EU states and inevitably mean that things will most likely move in the same direction but with different speeds and with varying effects. By being cautious, I speak from experience. As a researcher, I've been involved in various cross-border European studies, for example, on legal training in the EU member states, on the legal profession in Central and Eastern European countries, or very recently on tax advisors in the EU or bars in several Western European countries. Therefore, I know that a keynote, not even a full-day conference, can come to conclusions, but only formulate the very first ideas and approaches. It cannot replace many years of research that is yet to be carried out. My hope, therefore, is that today's event, my lecture, will provide initial food for thought for you to address this important topic as a whole through substantial, which needs to be researched properly through substantial research in the future. I will report on the future challenges for the legal profession based on experiences mainly from Germany. This is not so much due to the fact that I'm a German researcher. In my estimation, Germany is in some ways the blueprint for developments that we will see in many European states in the near or medium future. My keynote, therefore, is mostly a sounding board for you. You will need to consider to what extent the situation in your home country is similar to the situation in Germany, and then make an assessment how likely it is that things will move in the same direction as they are already moving in Germany, and how quickly that will be. So why is Germany a blueprint for the rest of Europe? Germany is one of the oldest societies in the world. The statistics on this question use somewhat different methodologies, but basically it can be said that Germany is the country in the world with the oldest population after Japan. More than 23% of all citizens in Germany are now over 65 years old, and thus at an age when they typically retire from working life. If we look further, we see that of the 30 countries in the world with the oldest population at present, 27 are in Europe. Japan, Canada, and Hong Kong are the only non-European states in the top 30 of this ranking. According to Eurostat's calculation, most of these European states will have to reckon with a population decline by the year 2100 as a result of their current and future age structure. The population in the EU as a whole is expected to decline by 7% over the next 75 years. While some member states, including Germany, are expected to experience low growth during this period, this means that many EU member states will be faced with a shrinking population. These include Italy, Spain, Poland, Romania, Greece, the Czech Republic, Portugal, Hungary, Bulgaria, and Finland, among others. And these are not necessarily the countries that are currently the one with the oldest population, and some of them thus may be unaware of the challenges they will face, not in the near future, but in the mid-term. The effect of an aging population on the legal workplace is twofold. More professionals will leave the legal profession in the coming years. To give you an idea, the German bar membership is already shrinking, although we are currently approximately 10 to 15 years away from those age cohorts with the most members reaching retirement age. This is nicely illustrated by this chart. Replacement demand is already considerable, but will increase dramatically in the coming years. An aging population also means that there are fewer and fewer younger professionals entering the workforce, which exacerbates the problem of meeting replacement demand. To use again the German example, you can see that the age cohorts between 30 and 40 are considerably smaller than the cohorts of those aged between 50 and 65. This leads to a first conclusion. Even if the attractiveness of the legal profession remained unchanged, it is inevitable that the pool of young people who could potentially be attracted to a career in law will become smaller, while at the same time replacement demand grows bigger. With regards to today's conference, its subject probably should be rephrased. We do not have to prevent the legal professions from becoming less attractive. No, we have to ensure that the legal professions become more attractive in order to attract a larger percentage from a shrinking pool of young academics to the legal professions. Is this realistic? Probably not. A few years ago, Markus Reif, Chief People Officer of the well-known consultancy Kienbaum, made headlines with an assessment that illustrated the dilemma facing all traditional professions, and thus also the legal profession. He stated, "In 20 years' time, 65% of our children will be working in professions that do not even exist in this form today." It means that traditional, some would say old-fashioned professions will compete with new, emerging, trendy professions of the digital age. For Generation Z and Alpha, entering a traditional profession is much less a natural choice than it was for boomers. I will talk about this later, but generally speaking, it is safe to assume that the future of the legal professions will depend on their ability to adapt, or, to quote Mr. Reif, that they will exist in a different form than they do today. I think it is also safe to assume that legal tech, that nowadays many see as a threat to the traditional legal professions, will be a necessary element of the future legal landscape, where less professionals will need to guarantee access to justice and the rule of law. As I said, Germany is more advanced in this development than other countries. As a result, in Germany, the legal profession has already stopped to grow. For 200 years, first-year students in Germany were welcomed with doomsday predictions that universities were producing much more law graduates than the marketplace could accommodate, that Germany was awash with superfluous lawyers. This has changed. There is no talk about a drought of lawyers. Over a 5% five-year period, 7.5% of all members of the bar in private practice have already disappeared. In some bar districts, this figure is twice as high. There are areas in Germany where 15% of members of the bar have disappeared since 2017. This is a dramatic departure from the past, when the rule of thumb was that the profession would double in size every 15 to 20 years. If the current development continues, Germany will have lost almost a quarter of all members of the bar in private practice by 2030, over a period of just 15 years. One could argue, and indeed some people do, that this is not necessarily a bad thing, and in a modern way, a modern dream come true of Dick the Butcher's much quoted wish in Shakespeare's Henry VI. The first thing we do is let's kill all the lawyers. The less legal professionals, the better. However, those who've read the Shakespeare well know that the phrase is ambiguous and can be interpreted differently. Some say it's a criticism of bureaucracy and the perversions of the rule of law, while others point out that Shakespeare really meant to say, was that lawyers tend to be a stable, lawful government's first line of defense in protecting the status quo and the rule of law. Indeed, the effects of a shrinking legal profession are problematic for the rule of law. In 2021, I conducted a survey with approximately 3,000 German members of the bar and asked what the effects of a shrinking profession have been based on their experience. And the respondents were asked to assess the situation today compared to the good old pre-2017 days, when the number of lawyers was still growing. On a scale from 1 to 4, 4 was I do not agree at all, and 1 was totally agree. And from a policy perspective, anything less than 4 therefore means a change for better or worse, depending on the view. Unsurprisingly, the biggest concern for members of the bar is the problem to recruit young talent. 81% fully or rather agree that this has become a problem. This is a finding that nicely chimes in with the subject of today's conference. What is, however, from a policy perspective more worrying is that the number 2 effect is that legal service providers are more often in a position to cherry-pick cases and deny the provision of legal services to those with supposedly unattractive cases. 64% fully or rather agreed that this has been an effect of a smaller number of professionals. 31% fully or rather agreed that it has become more difficult for clients to find a lawyer, 28% that it has become easier to demand higher fees from clients. And this is the overall picture. If you concentrate in those areas with the highest decrease of lawyers, access and costs have already become a much more bigger issue than elsewhere. When moving from members of the bar to judges, the development of the workforce is slightly different in Germany, but there are still problems. Unlike the bar membership, the number of judges has grown slightly over the past years and the number of court cases has decreased. But because of ever more complex and time-consuming court cases, recruitment demand has not been met, and court presidents have warned that the functioning of the court system is under threat. And the same is true, for example, for the public prosecution services. Strategies to address those shortcomings have mostly been limited to each specific branch of the legal profession. They pretty much follow the everybody is his own man and wash my fur but don't get me wet principles. There is no or very limited understanding thus far that if you serve yourself a bigger chunk of a cake of any given size, the others at the table will inevitably end up with smaller slices, which is only a workable approach if you're dealing with competitors. The different branches of the legal profession are, however, not competing but complementing each other. They have a symbiotic existence. One cannot exist without the other, at least not under the rule of law. Any strategies and solutions to address the looming crisis therefore must take a holistic approach. Today's conference, and indeed the newly established European Forum, is a good starting point as it brings all profession and stakeholders, at least from the supply side, to the table. When thinking about strategies to react to those developments, it is helpful to first get a clearer understanding of the background before which those developments have happened. So let me try to put that into perspective. In Western Europe, there was a strong growth of the legal professions from the end of the 1970s into the 1990s. There were several reasons for this. The politically desired and accordingly promoted growth of the so-called knowledge-based professions, including the legal profession. The political goal was to give more school leavers a qualification for tertiary education and encourage them to take up university studies. This led to an expansion of the higher education infrastructure and, with some time lag, also to a relatively strong increase in the number of academics and thus of members of the legal profession. At the same time, this growth was only possible due to a strong increase in the proportion of women in traditionally male-dominated courses of study and professions such as the legal profession. This growth potential on which the legal professions have relied on in the past decades has now been largely exhausted. Although the academization of the population in Germany, for example, continues to increase, more recently, mostly the engineering sciences and studies relating to information technology and social services benefited from this. In addition, academization at the current level takes place particularly at the level of University of Applied Sciences, which, insofar as they offer legal courses, do not lead to a professional qualification that would allow access to the traditional legal professions. It is also no longer realistic to rely on a growth in the total number of students through a further increase in the proportion of female students. In many countries, women have already been the majority of students in law for some time, and in some cases also in the legal profession. At my university, for example, in this year, around 70% of first-year law students were female. What does this mean? When we look to the future, we must be aware that the proverbial cake is no longer getting bigger. What we've taken for granted, that the pool of graduates from legal education is getting bigger and bigger and that the legal professions can recruit from this ever-growing pool, is no longer a certainty with which we can plan. Germany already in the present, others in the future. How soon your country will face this issue depends on a number of factors. To what extent has the potential of academization of the population already been maximized? How far has the gender shift in the legal profession developed? and how much to the detriment of traditional legal studies has the higher education landscape shifted, both in the subjects in the higher education institutions offering, both in the subjects and in the higher education institutions offering professional qualifications. Some of my fellow countrymen will raise an objection now and point out that contrary to what I've told you, the number of law students in Germany has recovered after a low a little more than 10 years ago. Since then, indeed, the number has been growing again, even if it's still far away from its former peak at the turn of the millennium. This is paradoxical because the bigger number of students is not reflected in a comparable growth on the number of new members of the bar, judges, or prosecutors. One explanation is that legal studies are increasingly used as a launching pad for non-legal careers. Another, that the percentage of students dropping out is increasing as a push for further academization leads to more less suited students entering universities. Even more important, however, is that the number of so-called alternative law degree programs has increased significantly over the past 20 years. Today, it is possible to study law without graduating with a law degree, qualifying the holder for a legal profession such as lawyer, judge, public prosecutor, or notary. These degree courses are often shorter than traditional legal training, which is usually characterized by an academic phase and practical training, often lasting up to a decade. And you can see this in this chart. The legal studies qualifying for traditional legal professions are the columns in dark green, whereas the light green and gray ones, they are legal qualifications that don't offer the opportunity to become a judge or a member of the bar. Typically, these courses are not offered by the traditional law faculties, but by universities of applied sciences or universities without a law faculty. These courses are often not designed to impart the broad legal knowledge that is characteristic of traditional legal studies. The alternative programs are not imparting basic legal knowledge of criminal law, civil law, and public law. In most cases, the legal subject matter is much narrower and combined with interdisciplinary studies and skills such as they are oriented towards specific needs of the employment market. In Germany, almost 30% of all law students now study in such alternative law degree programs, which did not exist in this form 20 years ago. I guess it is not too bold to assume that a significant percentage of students in these programs would have studied for a traditional law degree in the past, when this was the only option. No alternative legal studies were offered. Today, these young academics who are interested in earning their living with law are lost for the traditional legal professions, unless legal systems show a certain flexibility in the educational background of future judges, lawyers, or public prosecutors. Obviously, we need research to find out why an ever-increasing proportion of school leavers decides to study law but is not interested in earning money in the traditional legal professions. Therefore, the question of the attractiveness of legal professions is also, and perhaps even predominantly, the question of the attractiveness of legal studies in relation to other non-legal courses of study, but also to legal studies that do not qualify for the exercise of a traditional legal profession. One of the challenges is that this phenomenon is mainly discussed by judges, members of the bar, and civil servants who look down with a certain degree of contempt on what they see as a lower qualified caste of parvenu lawyers, and who often cannot imagine that this type of lawyer is in demand on the market at all. On the other hand, when talking to employers, these lawyers are seen as an attractive alternative to expensive, overqualified graduates with traditional law degrees, for example, in the legal departments of accountancy firms, tax consultants, large commercial law firms, corporate legal departments, or legal tech companies. The key question is why school leavers choose law but not a traditional law degree. Gaining clarity here is likely to be a central key to a successful response to the recruitment crisis. This brings us to a central aspect of our general topic, the expectations of future generation of legal professionals and how those are currently steering the ship meet these expectations. Those in charge as senior partners in law firms, as court presidents or heads of public administration belong to the generation of baby boomers, usually defined as those who were born in 1965 or before. Baby boomers are the quintessential definition of workaholics. They are used to working extremely long hours, to achieve results they want and believe that work ethic directly translates to work quality. Baby boomers take the view that positions of authority and power should be granted to those who have worked hard enough for it. Many baby boomers have sacrificed other pursuits such as families, vacation, and hobbies in favor of working the traditional way up the ladder. This contrasts with younger professionals who are now early or mid-career, the so-called millennials or members of the so-called Generation Y, born between 1980 and 1995. Millennials differ from baby boomers in that they aren't workaholics and view their worth as being defined by contribution as opposed to merit or experience. They want to have a voice and be involved in decision-making. Many millennials view their job as a means to an end and prefer to leave the office in the late afternoon rather than shortly before midnight. Other needs in working life are challenging work, development opportunities, and the desire for authenticity on the part of the employer. In short, equality, work-life balance, and purpose are the cornerstones of the millennial world, whereas the hierarchy, business, and results define the working life of baby boomers. These characteristics obviously create intergenerational conflicts. Legal professionals in general, and members of the bar in particular, have a widespread reputation for working long hours with little time left for private life and extra-professional activities. Profit per partner or the number of cases concluded are benchmarks in law firms and courts. Top-down management rules, long hours count. According to a study recently conducted with millennial lawyers, a law firm of the future should be innovative, family-friendly, have a flat hierarchy, pro bono work, work-life balance, personal development opportunities, and equal career opportunities. Almost all law firms, be they small, mid-sized, or large, obviously do not fit that bill, and many other employers in the legal sector do not as well. In the legal trade press, there is quite a lot of talk about those intergenerational challenges. Pledges to rise to the challenges are made by employers. The real-life reaction, however, is relatively uninspired. Those who can afford it, mostly larger law firms and companies, are paying higher and higher salaries. In Germany, the top salaries of first-year associates now exceed those of the most senior judges in Germany, except for the 16 judges at Germany's Constitutional Court. Those employers who cannot lure graduates with ever more money, notably the court system and government employers, are lowering their requirements when it comes to degrees and skills. Of course, these approaches do not solve the underlying problem, and it is foreseeable that sooner rather than later those problem-solving strategies will no longer be functional. I could easily talk about intergenerational challenges in the legal professions for hours, and I would urge this forum to look into this aspect in greater detail in the course of its work, particularly as the Generation Z, with another set of different characteristics, is already knocking on the door of employers, and Generation Alpha is now entering high schools. But given time constraints, let me move to another important cornerstone of our general topic, the gender shift in the legal professions. Even more than other academic professions, the legal professions were strongly male-dominated for a long time. This is even more true for the professions of lawyers and notaries than for those of judges and public prosecutors, at least in those countries where the judicial professions can be entered immediately after completing legal training. In 2007, I established a statistical yearbook of the legal profession, which I still publish today, and the yearbook contains a table on the gender balance in the European bars. And a comparison of the first and last edition of the book shows that in the past 15 years, the proportion of women has increased significantly in almost all countries, mostly between 10 and 20 percentage points, in some countries even more. The exception are some of the Eastern European countries where, as a legacy of the past, the proportion of women in the legal professions has traditionally been somewhat higher than in Western Europe. When members of the bar and also more generally legal professionals retire today, the retirees, and I do not mean this disrespectfully, are overwhelmingly old white men. Those who fill their positions in the professions are in the majority young women. Even in countries where this is not yet the case, the legal professions of the future will be dominated by female professionals. The resulting challenges, especially outside the civil service, are yet to be met. This can be illustrated by a statistical spotlight from Germany. In Germany, the proportion of female lawyers among newly admitted professionals has been relatively stable at 50% for some time. And this is, by the way, approximately 10 percentage points less than the proportion of female law graduates, and shows that women obviously aspire more often to work in the judiciary, in public administration, or take up activities outside of the traditional legal professions. The real problem, however, lies in the two detailed findings. Within a decade of professional activity, the proportion of women decreases by almost 10 percentage points. The bar is thus losing a considerable number of young female lawyers who were attracted to the profession initially, maybe with some difficulty, but they obviously became disillusioned and decided to leave. And we are talking here about young talent on which the bar will have to rely on heavily in the future. At my university, as I mentioned, for example, almost 70% of first-year students are now female. In addition, a disproportionately high number of women who become members of the bar are in-house counsel. They work in the legal departments of companies or associations, but are not in law firms. The bar, as the most important and largest subgroup of the legal professions in terms of numbers, is therefore particularly affected by gender-specific change. Women are underrepresented in this subgroup among those entering the profession. They leave the profession more often than males after a few years, and if they remain in the profession, they are particularly often not in private practice, but in companies or associations. In recent years, I was involved in a study that examined the professional and private lives of lawyers in Germany, in France, Belgium, Spain, and Luxembourg. From the findings of the studies, the reasons for this development are quite clear. I do not have the time today to go into the study in detail, but it is quite obvious that women are more often than men experience employer discrimination due to private commitments, are forced to work part-time, which hinders their careers, report a lack of support structures, and an unequal distribution of family-related obligations between parents. They also have less time for personal needs and are less satisfied with their work-life balance. Those findings should not be seen as a specific problem of albeit numerically the most important branch of the legal profession. For those weighing their options before starting tertiary education at university, the attractiveness of the legal profession is inevitably defined in particular by the profession that is statistically the one most likely to be taken up after graduation, voluntarily or involuntarily. Those branches of the legal profession that are not part of the public service are a subgroup of the liberal professions. Liberal professions are based on specific professional qualifications or creative talent and are characterized by the personal, autonomous, and professionally independent provision of services in the interest not only of their clients but also the general public. Liberal professions are traditionally practiced in an entrepreneurial way. The gender shift in the profession therefore creates challenges. Women, as research shows, are significantly less interested than men in practicing a legal profession in an entrepreneurial way. They are much less likely than men to regard professional practice and employment as a transitional job. Their interest is often to remain permanently employed and not to move to partner status. And the same is true for many young male lawyers who belong to the so-called Generation Y. They are unwilling to cut back on private life, family hobbies to an extent that is typically required to become an entrepreneur. The traditional organizational structures of the liberal professions cannot accommodate these expectations or wishes. This is a particular problem in those jurisdictions where the profession is typically no longer practiced by sole practitioners but in larger entities whose management requires considerable entrepreneurial commitment. If for many young lawyers the alternative to an undesirable entrepreneurial activity is at best a rather precarious employment as a freelancer in law firms, and if full-bodied promises made by employers to offer modern employment concepts are not kept in reality, this also weakens the attractiveness of the legal professions as a whole. One may complain about the lack of entrepreneurial spirit by the young generation, but whining does not change the realities. I'm convinced that in the long term we cannot avoid thinking about the unthinkable for many, such as abandoning the idea that law firms must always be owner-managed, that outside capital and the associated external management are taboo, not because we want this, and consider it desirable, but because there is no better alternative to keep the legal system afloat. Another finding, which I frankly do not know whether it's a peculiarity of Germany or an expression of a general problem, is the weak representation of minorities or persons with a migration background in the legal professions. Interestingly, law studies in Germany are quite popular among school leavers with a migration background. This may also have something to do with the fact that more traditional subjects, such as medicine or engineering, have always been particularly popular among those with a migrant background as a means for social advancement. However, only a fraction of students with a migration background end up in the legal professions. This may due in part be to the fact that these individuals are less likely to complete legal education. However, this cannot be the only explanation. Even if some legal professions are not open to these individuals because of nationality requirements, the data suggests that there is a considerable untapped potential here. While it was never right from a policy perspective to refrain from systematically raising this potential, in times of recruitment problems in practically all legal professions, this reservoir should be exploited as best as possible in the future. The times when one could rely heavily on so-called academic reproduction, lawyers' children become lawyers, they are long over. So embracing diversity is also exploiting a potential that has not been raised so far. So let me conclude. As you know, Benjamin Franklin once said, "Nothing can be said to be certain except death and taxes." And I would also add, also not demographics and generations X and Y will not change. Those are the two certainties with which we have to deal. So what are my final suggestions or recommendations? All legal professions must pull together and not primarily protect their own turf. I think it's necessary to start from scratch. Legal studies must be attractive, not only legal professions. There is a need to find out if there's potential for more academization, and if so, if legal studies can benefit from that. We should try to better understand Generation Y and Z, as we have no choice. So it's necessary to accommodate expectations and then also walk your talk. And consider that the gender shift and intergenerational differences mean that learned occupational models of the legal professions will struggle to survive. And finally, rely less on academic reproduction and improve or rely more on social advancement of school leavers. Thank you very much.